Okay, I hope it's clear now. Okay, so when we talk about Section 7 talks about designated partners, and designated partners are those partners which are representing the organization in the eyes of law for all the activities in front of registrar office. So when we talk about the fulfillment of requirement in terms of we can say that submission of accounts, submission of returns, fulfilling other contraventions or requirements of the law, which the LLP is required to make, is considered as the responsibility of the designated partners. When we say who is going to be the designated partner, then the designated partners can be individuals, can be body corporate, can be LLP. तो अगर हमारे इंडिविजुअल आपके डेजिग्नेटेड पार्टनर होते हैं तो मिनिमम 2 डेजिग्नेटेड पार्टनर होने चाहिए एंड आउट ऑफ द 2 डेजिग्नेटेड पार्टनर one should be resident in India. And if we talk about the body corporate or LLP are the partner of LLP, then in that case, their representatives or nominees shall be considered as the designated partners. So, who is going to be the designated partner? The individual or the nominees in case of the company or the LLP. And if we talk about resident in India, so as per Income Tax Act, there are certain conditions to be resident in India. So that is the basic condition is that the person must have stayed for at least 182 days in India during the relevant previous year. Now we talk about that when we talk about the designated partner, तो जब हम इनकॉर्पोरेशन ऑफ एलएलपी के लिए अप्लाई करते हैं तो उस इनकॉर्पोरेशन डॉक्यूमेंट में जब हम स्पेसिफाई करते हैं डेजिग्नेटेड पार्टनर्स को तो वो डेजिग्नेटेड पार्टनर बन सकते हैं. अदर देन दैट अगर हम एलएलपी एग्रीमेंट के हिसाब से टाइम टू टाइम designated partners के बारे में बताते हैं, then in that particular case every partner shall be designated partner in accordance with the LLP agreement provisions. Then after that we say that every partner may become designated partner as per the LLP agreement, and every partner may be discontinue to be a designated partner, and again it would depend upon the provisions of limited liability partnership agreement. Other than that, if we talk about the individual, so then he shall not be become a designated partner if he has not given his consent for the same. And also, if the consent, every limited liability partnership must give the particulars of that individual only who has given the consent to act as designated partner. तो अगर LLP ऐसे पार्टनर का नाम दे देती है जो डेजिग्नेटेड पार्टनर के लिए जिसने कंसेंट नहीं दी, then that particular person cannot be appointed as the designated partner. So all the conditions and requirements must be satisfied. So to become the designated partner must acquire a DPIN number which is issued by the central government as per the provision of the act, and proper formalities have to be filed in to obtain the DPIN number. DPIN number is the identification number issued by the central government to an individual who is appointed as a designated partner of LLP, and this particular number is required to be obtained, and in case a person is holding DIN and DPIN both, then DPIN shall stands cancel. So DIN is the director identification number. So if a person is holding the director identification number, तो अगर उसको DPIN नंबर भी मिल जाता है तो वो आपका कैंसिल हो जाता है. सो इन दैट पर्टिकुलर सिचुएशन यू जस्ट नीड टू रिमेंबर दिस थिंग, एंड अगर कोई भी पर्टिकुलर्स में चेंज होता है सो इट मस्ट बी कम्युनिकेटेड टू द रजिस्ट्रार विद इन 30 days of such changes. Then we talk about that when we say the duties of the designated partner. So they are responsible to do all the acts, filing of return, or making the statement, fulfilling the requirement, or fulfillment of any other provisions of the act which are required. So their responsibility is to do all the acts or matters which are required to be performed by the LLP, and because designated partners are representing the LLP, so they are required to do all these acts. और अगर डेजिग्नेटेड पार्टनर वो परफॉर्म नहीं करते हैं या कोई भी एलएलपी की एक्ट की प्रोविजंस की रिक्वायरमेंट फुलफिल नहीं होती, then the designated partner shall be held liable for contravention of those provisions. Then after that we say that they will be required to perform all the activities, filing of documents, returns, statement, like report, etc., and other provisions which are required to be performed by the LLP. Then we say that if we talk about the responsibility and authority, so they are required to perform, and if there will be any kind of they are not negligent in performing, then they will be excluded from the liability if they successfully defend themselves that they were not part of the particular requirement. Now, when we talk about the whether there can be a change in the designated partner, so it is said yes, LLP may appoint designated partner within 30 days of the vacancy. If there is no designated partner appointed and one designated partner at a time, then each partner shall be treated as designated partner. This provision is very important कि अगर किसी भी टाइम पे आपका डेजिग्नेटेड पार्टनर एक ही है और 30 डेज के अंदर एलएलपी ने वो वैकेंसी फिल नहीं की है, तो उस केस में सारे के सारे पार्टनर्स जो हैं एलएलपी के वो डेजिग्नेटेड पार्टनर माने जाएंगे. Then after that there is requirement the same is there. This particular clause explanation is being given section 9. Section 10 says कि अगर आपके कोई particulars में change है और अगर आपका डेजिग्नेटेड पार्टनर वैकेंसी है और आप उसमें अपॉइंटमेंट नहीं करते हैं या डेजिग्नेटेड पार्टनर्स की डिटेल्स नहीं देते हैं, तो उससे रिलेटेड अगर कोई भी कॉन्ट्रावेंशन होती है प्रोविजन की, तो उस पर्टिकुलर सिचुएशन में जो बॉडी कॉर्पोरेट के नॉमिनीज हैं या डेजिग्नेटेड पार्टनर एज एन इंडिविजुअल हैं, they will be imposed with a fine which can be 10,000 and can extend up to 5 lakh rupees. Then if there is contravention to any of the provisions of section 4, 5 and 7, then in that particular case the LLP and every partner is liable for fine up to 1 lakh rupees. Then section 11 of incorporation document of LLP, I think we have already covered this particular aspect कि पर्टिकुलर एलएलपी को इनकॉर्पोरेट करने के लिए हमें एक प्रॉपर इनकॉर्पोरेशन डॉक्यूमेंट प्रॉपर फॉर्म में सारी डिटेल्स देनी होती है, जिसमें ऑब्जेक्टिव ऑफ बिजनेस, पार्टनर्स डिटेल्स, टू डेजिग्नेटेड पार्टनर्स डिटेल्स and other attachments are required. A detailed LLP agreement may not be attached. In that case, Schedule 1 rules will apply, and along with the prescribed fee when it is being submitted to the registrar of the companies where the particular registered office of LLP is to be situated. Then if all the conditions are being satisfied, then within 14 days of submission of the document, the registrar is going to issue the certificate of the incorporation of the LLP, and this certificate issued will be the conclusive evidence for the existence of the LLP. And if there is any changes in the registered office of LLP, then it must be communicated in the prescribed form, and in case there is a change in the registered office, so if the notice is not being given, then in that particular case, every partner shall be punishable with the fine, which will be from 2,000 to 25,000 rupees. Then with respect to, if we talk about what is going to be the effect of registration, then in that particular situation, their LLP is being registered and it exists as a separate legal entity. It can enter into the contract in its own name, it can purchase the property, it can file a case against the other entities, etc. All the things which are allowed to a body corporate, the same activities will be allowed to the LLP as well. Then section 15 says that LLP should be attached with its name, and any name which is being filed for the registration, that should not be similar to any existing organization or any undesirable name by the central government, then only it is going to be approved. And when it is approved, you have to take the evidence, and in that case the LLP word is to be attached. If we wish to reserve our name for the LLP, and formalities are taking time, so the prior 3 months, we can, for the 3 months period, we can reserve a name for our organization for which we want to exist as the LLP. If there is change in the name of the LLP, then in that particular case, the directions should be followed, and within 3 months period, and any period, if extension is required, it only central government is empowered to give that extension. Otherwise, it is to be done within 3 months period only. And if there is any contravention in fulfillment of the requirements of this provision, then there is going to be a fine of 10,000 rupees, which may extend to 5 lakh rupees. And every designated partner shall be punishable with a fine of 10,000 rupees, which may extend to 1 lakh rupees. Then if we say application for direction to change name, so if the LLP has proposed a name which is already similar, or already any LLP or other organization exists, then there can be the change can be given along with the prescribed fee, and such application will be accepted by the registrar if this particular change happens within 24 months from the date of incorporation. Then after this, if we are not using the name LLP, or we are using improper words, or we are not mentioning the particular organization name as LLP, then in that case the fine of 50,000 rupees, which may extend to 5 lakh rupees, can be imposed on the organization. When a particular LLP is being registered, so it is required on all its documents, letterheads, bills, or at the registered LLP place, the word LLP is to be attached, and if it is not attached, then the fine of rupees 2,000 rupees can be imposed, which may extend to 25,000 rupees. Then we talk about the consent of the partners. So all the partners must be name must be given in the incorporation document, and consent of all the partners should be there as to act as a partner of the LLP, and all the terms of the they will be termed as partners of LLP, and their role within the provisions of LLP agreement. So they are supposed to work as per the details given in the LLP agreement. So they must have given consent to all the things in the LLP agreement. Moreover, they must have agreed upon to act as the partners in the organization. If we talk about the relationship, section 23 talks about, and we have already discussed that very important aspect, that is the rule of mutual agency does not exist in LLP. Here every partner may represent the LLP in all the courts of transaction and contracts. They work as the agent of the LLP, but they cannot bind the other partners. And even if one particular partner has done something wrongfully, then in that particular case he will be having the unlimited liability, but he cannot bind the other partners. Only LLP assets can be attached for that. So in this case, when we talk about the relationship, so all the rights and liabilities and duties of the partners shall be as per the LLP agreement, और अगर LLP agreement silent होता है तो शेड्यूल 1 की डिटेल्स उसके अंदर अप्लाई होंगी. उसके बाद अगर कोई ऐसी सिचुएशंस हैं जिसमें इनकॉर्पोरेशन डॉक्यूमेंट में कुछ डिटेल्स मिसिंग हैं, और इन दैट पर्टिकुलर सिचुएशन द इनकॉर्पोरेशन डॉक्यूमेंट मस्ट बी रेटिफाइड आफ्टर द इनकॉर्पोरेशन ऑफ LLP. देन LLP के अंदर वो पार्टनर का इंटरेस्ट कब खत्म होगा, और व्हेन ही विल बी कंसिडर्ड एज सीजेस टू बी द partner in the organization, then that particular case, by choice, he can give 30 days notice to all the partners, and he can resign from the partnership firm. The person will not be considered as partner as anymore. In case of death of the partner, his legal representatives will have no role. In case of dissolution of LLP, if a person is suffered from unsoundness or insolvency, or a person is declared as adjudged insolvent, then in all these cases he will not be considered as a partner of the LLP. His interest as a partner will be over in the partnership firm. Then the person who is resigning or who is leaving the particular LLP will be known as former partner. लेकिन अगर वो फॉर्मर पार्टनर डिक्लेयर हो गया है बट उसमें पब्लिक नोटिस नहीं दिया तो उसकी लाइबिलिटी थर्ड पार्टीज की तरफ बनी रहेगी एंड वंस द पब्लिक नोटिस इज बीइंग गिवन then he will be responsible only for the past transactions entered into by him. He will be held liable for his liabilities during the period before leaving the organization, not after that. But अगर उसमें third parties को notice नहीं है and they have entered into the contract with the former partner, then the former partner shall be having the liability for the same. Then after that, once the partner leaves the organization, तो उस particular situation में अब उसका कोई भी right नहीं होगा up to amount of capital contributed and accumulated profits and adjusted losses के अलावा उसके अलावा कोई भी उसका right नहीं होगा. So for with respect to the capital, accumulated profit less adjusted accumulated losses will be there. And if the former partner has this particular partner has died, so his legal representatives will not have any right in the management of the LLP after the date of resignation or death of the partner. Then after that there comes that if there is any change in the partners, then such change must be communicated within 15 days to the registrar. If there is every partner is required to register any change in his name or address within 15 days, and LLP is required to inform registrar within 30 days period from the change of the name, address of the partner, or if there is any change in the composition of the partner, all the details must be given to the registrar of the firm. Then after that, if the notice is required to be filed with the registrar in the prescribed form, in the prescribed fee, and must be signed by the designated partner, must be confirmed, certified, authenticated by the designated partner that such an information is true and correct. And if there is any changes to an incoming partner, then the statement of the consent must be signed by the incoming partner and authenticated in the prescribed manner. तो composition of partner तो admission के time भी change हो सकता है और retirement के time पे भी change हो सकता है. So in that particular scenario, whatever changes are there, designated partners will have to authenticate the particular transaction or particular situation. देन अगर ऐसे ये प्रोविजंस आपके कंपाइल नहीं होते और कॉन्ट्रावेंशन होती है, आइदर कंसेंट नहीं दी या फिर आपके डेजिग्नेटेड पार्टनर ने उसको ऑथेंटिकेट नहीं किया या विद इन 30 डेज रजिस्ट्रार को कम्युनिकेट नहीं किया, then in that case there is going to be the fine where designated partner shall be punishable with the fine of 2,000 to 25,000 rupees. And if there is the LLP changes in the name and address, then in that case LLP is 2,000, which may extend to 25,000 rupees. If the partner himself leaving the organization inform the registrar और 15 दिन में LLP से या organization से कोई confirmation नहीं आती, wherein the registrar have sent the confirmation or going to confirm it from LLP, then in that particular case registrar उस partner को partnership firm से relieve कर देता है, and that is there is partner have the right to communicate, because until unless there is a proper notice is being given, he will be held continuously liable for all the transaction which happen even after leaving the organization. तो अगर किसी भी सिचुएशन में ऐसा होता है कि पार्टनर फील्स दैट द LLP is not going to inform the registrar of the company, then he himself may go and apply or for the confirmation that he is going to leave the organization. So accordingly action will be taken, and if confirmation is not received within 15 days, तो उस केस में registrar उस partner को उस LLP से उसका नाम struck off कर देता है. Then section 26 talks about the agency relationship, wherein we have already discussed that in case of agency relationship, every partner of LLP acts as an agent of LLP and has no capacity to bind the LLP for conducting the business transactions. It is specifically provided that partners of LLP cannot bind the other partners and do not act as an agent for the other partners. So that is very, very important. Section 27 talks about extent of liability of LLP. So in this case, LLP is not bound or liable if partner has acted beyond his authority or fraudulently or any wrong act. Then in that particular case, LLP will not have any responsibility if the third party with whom it has entered into the transaction was aware of the authority of the partner, and that again, that if the other party has acted in good faith, then in that case LLP shall be held liable or the partner shall be held personally liable as the circumstances may be. Then if the any wrongful act by the partner is being done in the regular course of transaction and partner has acted within his authority, then LLP shall be held liable for the same. And also LLP shall be held liable for all the obligations which arise out of a contract which have been entered into by the partner on the behalf of the LLP, and all the liabilities will be met from the property of the LLP itself. Then extent of liability of partner says that a partner is not personally liable with respect to any obligation arising out of a contract while carrying out LLP business. So there is no unlimited liability, no personally liability except in two circumstances where the partner himself have done something wrongfully or fraudulently. Second, where the partner has continued the activities of the partnership firm as a single partner beyond a 6 months period. So in these two cases, the partner will be held personally liable. And for any wrongful act or omission, any other partner shall not be held personally liable, but he will be held personally liable for his own wrongful act or omission. So there can be a small question that in limited liability partnership, partners have the limited liability. Their liability is not personally, or their liability is not extendable as in the partnership firm. But in certain circumstances, partners might have unlimited liability. Discuss those circumstances. So then you have to mention these two circumstances where the partners are going to have the unlimited liability. So section 30 talks about unlimited liability in case of fraud. So it says that if any activity is carried out by LLP to defraud others, then there will be unlimited liability of LLP and partners who have acted to defraud the others. If any business is carried out with an extent to defraud others, then every person involved shall be punishable with imprisonment, which may be up to 2 years, and fine of 50,000, which may extend up to 5 lakh periods. Then after that, in a particular situation, LLP or any such partners or designated partners are also liable for compensation to the person who has suffered the loss because of the particular reason. तो पहला तो अनलिमिटेड लाइबिलिटी रहेगी. सेकेंडली जो भी पार्टीज उस डिफ्रॉडलेंट एक्टिविटीज में इन्वॉल्व होंगी, they will be punishable with the imprisonment and also with a fine of 50,000 to 5 lakh rupees. And thirdly, they are required to compensate the other parties with respect to the loss suffered by the other parties on account of fraudulent activity conducted by the LLP and his partners. Last section for today's class, I am touching upon whistleblowing. The conversion we will discuss in the next coming classes. When we talk about the whistleblowing, whistleblowing is the protection provision given under the provisions of law, which states that if some wrong activity or defraudulent activity is going on in the organization and any person communicates the higher authorities or the legal representatives about such an activity, or at the time of vigilance or any procedure going on, supports the authorities with respect to the required information, then as per the whistleblowing provision, interest of such person, such whistleblower are being protected by law. So the provision says, as per this provision, the court or tribunal may reduce or waive off any penalty imposed against any partner or employee of LLP on the basis of providing useful information during investigation and in another situation where information is provided while carrying out any legal proceedings. And as per this provision, no partner can be compelled or demoted or suspended or threatened on the basis that he has provided the information. So such an information is being provided to support, to fulfill the requirements of the law, to blowing the whistle or raising the alarm to protect the organization interest and the interest of the public in general. So in that case, the person who has blew the whistle, his interests are being protected, and in certain situation where the penalty is imposed on the all the partners or on the organization, so penalty for such partners who has provided the information may be reduced or may be waived off as per the discretion of the court of law. So that is the provision of whistleblowing. So there can be a short note on whistleblowing provision or 2-3 mark question on whistleblowing provision. So I think we can stop here, and the remaining with respect to the accounts and other things, and as well as if we talk about the conversion of different form of organization into LLP, we can discuss at the coming classes.